Ryan Brown from J. Ryan Brown Law today. Sorry for the background. We're having a little technical difficulties today, but wanted to make sure we got this video out on schedule. So today we are talking about DUI cases in Georgia and the stringent 30-day requirements and kind of some myths that go along with those, okay? So in Georgia, if you get a DUI, the officers most times, a lot of times are going to, depending on your jurisdiction, are going to take your driver's license and issue you what's called a 1205 form. Okay. The impact of this 1205 form and what you need to do may vary from case to case and depend on whether you consented to a chemical test of your blood or breath or urine, or whether you refused. So there's a lot of kind of myths about this. Some people think there's a 10-day deadline. There used to be. Now it's 30 days. Some people think that there's a 45-day deadline. That's also incorrect, but you do have 45 days to drive generally on the 1205 form. However, the decisions you must make within 30 days are going to be whether to file an administrative appeal of your license suspension. We call that ALS paperwork. This is something that goes to the administrative courts where we say, hey, for some reason, we should avoid this license suspension or we're going to contest it, whatever it may be. Your lawyer will talk to you about that in detail, but there requires a letter to be sent to the Department of Driver Services as well as a $150 appeal fee. In some cases, an ignition interlock device may be the most appropriate option for you. A lot of times we see this in refusals where someone refused to take a chemical test. Then the ignition interlock, may be the best option for that driver. Again, this is a case-by-case analysis that you are going to discuss with your lawyer. But if that happens, you must A, get the device installed in your vehicle, and B, go to the Department of Driver Services and obtain a permit within that 30-day deadline. And the reason that's so important is that keeps you able to drive during the pendency of your case. For instance, if you refuse a chemical test, so if you refuse a blood test, or refuse a breathalyzer test, and you don't act within this timeline, you'll be facing a hard 12-month suspension of your license, meaning you can't drive to school, to work, to the grocery store, or anything. It is an extremely devastating consequence for simply saying, you know what, Mr. Officer, I'm not going to partake in your little dog and pony show here and not incriminate myself. Or maybe you're not going to incriminate yourself, but not going to, let the government stick a needle in your arm and draw blood. So the only way to protect yourself from that is to act quickly. You must act within 30 days and get that paperwork in. Again, stay tuned. Follow us on all of our on Twitter and Instagram and LinkedIn and YouTube, because the rest of the month, each Friday, we're also going to be talking more about DUIs. But just know the deadline in Georgia, as we sit here today, to get paperwork in is 30 days. It is very important that you hire a lawyer quickly when you're charged with a DUI so that they can get things done before that 30-day deadline. If you wait until the last minute, day 28 or 29, it may impact your ability to even explore the permit as an option, and it may make the decision much tougher for you. So don't put yourself in that spot. Act quickly and let your lawyer start fighting for you. Try to save that driver's license.